Back on the record, and again, providing public access both in the courtroom and also online.
And here we go. Another day, another courtroom drama. But this one, it comes with more twists than a soap opera. Sentencing, contempt, bond violations, and even a redemption arc. Buckle up, because this ride goes from tense to downright surprising.
Well, our last case this afternoon is People, State of Michigan versus Robert Appleford. It's file 24-6930FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Flint County Prosecutor.
Attorney Sodium Panayin, KP number 85326, appearing on behalf of Mr. Robert Appleford.
All right, good afternoon. And we are here for sentencing.
This isn't just any charge. It's a third offense domestic violence case. In Michigan, that means we're no longer talking misdemeanors. This is felony territory. With up to 5 years max translation, the stakes couldn't be higher.
On an attempt domestic violence third offense, it's a 5-year maximum. Advisory guidelines were scored at 0 to 17 months. Mr. Penante, have you had a chance to review the report and recommendations with your client?
I have, Your Honor, and I would like to add and thank the court's probation department. In none of the jurisdictions that I practice do I receive a PSI a month in advance.
Oh. Any additions or corrections to that report?
None, Your Honor.
The guidelines were scored at 0 to 17. Any scoring challenges?
None, Your Honor, from defense.
Ms. Goodrich, any additions or corrections or scoring challenges from the people?
No, Your Honor.
Okay. Agent Fagan, the only change that I would ask is that on the attempt.
Quick breakdown. The judge is clarifying sentencing math. Even though it's an attempt charge, the maximum penalty doesn't shrink. It's still 60 months. Basically, Appleford's facing the same max prison time, attempt or not.
The statutory maximum would remain the same, although it does change the class. So it still is a 60-month statutory maximum, not the 2.5. To make that change on the page 1 and on the SIR. All right, before we go into sentencing allocution, though, we do also have a show cause that was filed. So, Mr. Penante, you've received a copy of that?
I have, Your Honor.
So, Mr. Appleford, it is alleged that you are in contempt of court for violating the conditions of your bond.
And there it is, the bombshell. Appleford didn't just show up for sentencing. He showed up with fresh violations, contacting the victim and drinking alcohol. In court terms, that's like showing up to the fire station with gasoline.
By having contact with the victim in this case, and also by consuming alcohol. You have the right to have a hearing where those allegations would need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer at that hearing. And if I find you in contempt, I could jail you for up to 93 days or fine you for up to $7,500 or both. Also, if I believe that you're not complying with the conditions of your pretrial release, I can revoke that release. So, Mr. Penante, Mr. Appleford, do you understand the rights that you have and the maximum penalties you can face for the contempt?
Yes, sir.
Okay, Mr. Penante, do you know how Mr. Appleford wishes to proceed on the contempt allegation?
I'm not certain, Your Honor. We received the violation yesterday.
Okay. So, Mr. Appleford, how do you plead to that violation, guilty or not guilty?
Not guilty.
All right, so we'll have to set this for a hearing then. I guess, the outcome of that may have an effect on the sentencing decision. So I suppose, do we want to just proceed to a hearing right now?
Now, here's the dilemma. Should they deal with this contempt charge immediately or push it off? Imagine you're the judge. Do you hammer him now or give the defense breathing room? What would you do?
What's your request?
Your Honor, since it's a bond violation hearing, I did not print off the text messages and stuff that I would
Oh,
use
that's
to
right.
prepare for
That's
that.
right, because it was okay. All right, and for the defense too, we're just arraigning you on it, so we should. Mr. Penante, would you like this set for a contested hearing then?
I would, Your Honor. I
Okay.
would again reiterate, I received these yesterday.
Yes.
It's not particularly a complicated matter, but we will need some time to formulate a defense.
That's true. Are you available in 2 weeks, August 26th? I'm in particular thinking the morning, say at 9:30.
I have a preliminary examination, Your Honor, but I also have a law partner who will take care of that on my behalf, and I will be here for Mr. Appleford.
So we could set this on August 26th at 9:30 in the morning for a hearing on the contempt. And we should probably continue the sentencing until that date and time. Would you agree, Mr. Penalty?
I would, Your Honor.
Ms. Goodrich?
Yes.
So I suppose I'd like to hear from both parties then about any pretrial release or any release between now and then. Mr. Penante, on behalf of Mr. Appleford.
Yes, Your Honor. Mr. Appleford owns a local area business. If the court were to require him to post a bond, he is able to post a $1,000 cash bond today, pending that hearing to ensure his attendance and ensure his future compliance with any court orders. If the court's inclined to do that, he'd be able to do that today, I would point out. Otherwise, the allegations are communication by text message. They're not allegations that Mr. Appleford appeared at the victim.
Notice how the defense is spinning this. Hey, these were just text messages, not stalking or showing up in person. But in domestic cases, even digital contact counts as a violation. Courts treat it seriously because it keeps victims in that cycle of intimidation.
His residence. There's not allegations of stalking. I do know that there is an impact statement that has been submitted in regards to the sentence referencing prior incidences, but otherwise, text message communications, such as they are, don't further endanger the complaining party. It's also my understanding that the parties had a very, how should I put this? Contested, difficult divorce that underlies all of this. There's not allegations of new criminal conduct in the meantime. I would ask the court to set a bond.
Thank you, Ms. Goodrich.
Your Honor, the concern here is that we're here on a status conference on a prior no contact violation that was filed and then received a second one. I realize it was just yesterday. We do have a quick hearing date for August 26th to prevent the victim from any further contact with the defendant. I would ask for the bond to be revoked until that date.
All right, well, we've got a few different factors here, Mr. Appleford. I mean, one of them is the even based on the allegations, you know, the victim is participating, if you will, with contacts and conversations with you, and sometimes they're aggressive on one side or the other, or both. So there's some mitigating factors there I'm aware of, which is why normally in an assaultive case, when there's a violation of no contact, bond is almost always revoked, as it should. In this case, it wasn't back in June. Because of exactly what I just said, some of the mitigating factors. So we've just kind of been tracking that contempt. So you're already under a show cause order for having contact with Apple. Also, you entered a plea into the case, which means you're no longer cloaked with the presumption of innocence, and the case law is clear that bond post plea.
Translation: once you plead guilty, bond is a privilege, not a right. Appleford had already admitted guilt, meaning the judge had every reason to slam the door shut. And guess what? He does.
It's entirely discretionary with the court. And now, despite those two things, there's allegations that you're continuing to have contact with the victim, and there's text messages that apparently document that. Under these circumstances, I'm going to revoke your release, and you'll be remanded to the custody of Sheboygan County Sheriff.
Boom! Remanded. Appleford goes straight from court to jail. No going home, no last-minute excuses. It's the legal equivalent of the judge saying, game over, you're done.
Until further order of the court, and the next hearing will be August 26th at 9:38. All right, we'll be adjourned.
Thank you.
All right, we're back on the record and we have a,
Sit down.
Wait, talk about a tone shift from remand to redemption. The next case is a man asking the court to erase decades-old convictions. From downfall to second chances, this courtroom really has it all.
we've got a motion to set aside conviction in, looks like 2 files, 1989, 0306 FH and 0319 FH. Counsel, you want to state your appearances?
Yeah, good afternoon, Your Honor. Daniel Osnick on behalf of Fred Wooler, who is seeking to have convictions expunged.
Melissa Goodrich, Wayne County Prosecutor.
Okay, and it looks like the statutory requirements are satisfied, so it's more a matter of some testimony about his behavior and doings since then.
Okay.
So your client want to take the stand?
Yep, please. Yep. I have a proposed order, Your Honor.
Okay, thank you. Do you want to raise your right hand for me, Mr. Willard? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, self-evident? Yes. Please be seated. Go ahead, Mr. Losny.
Thank you, Your Honor. Would you state your name for the record?
Frederick H. Willard,
And Mr. Willard, where do you reside?
11253 Coyote Ridge, Sheboygan County.
And it's Indian River?
No, it's actually in a Lansing address.
Lansing,
because
okay.
The mailbox.
And how long have you lived there?
Since '08,
Okay. Do you live there with anybody?
not at this time.
Okay. Are you single then?
Yes,
Do
yes.
you have children?
No.
Your occupation?
I own Fred's Tree Work Landscaping and Excavating.
So you're self-employed as a landscaper?
Mostly trees and excavating, but yeah.
And how long have you been doing that?
Since, since we were in trouble in '90,
Okay.
so long time.
And when you say we,
Me.
you, right?
Well, you were my attorney then
Yeah,
too.
right. So,
Sorry.
um,
Lumping you in there, sorry.
you have petitioned this court to have 2 convictions set aside.
Yes, sir.
All right. And you completed your probationary terms.
Yes, sir.
What did you do to rehabilitate yourself from your involvement with controlled substances?
Well, I spent 7 months, I believe, in Newberry in the in-house rehabilitation.
Okay.
And then after that, we had lots of AA meetings and just continually went with the people that never do drugs. You know,
Changed
just
your
surrounded
circle.
myself with other folks.
Yeah. Okay. And have you had any convictions of any criminal activity since then?
I did get in trouble in '08 for shooting a deer.
And what was the results of that?
I paid some money.
A fine?
Yes, there was no probation.
Okay. Your employment, do you have employees?
Yes,
How many employees do you employ?
different jobs take different employees, but 2 to 5.
Okay. And your work is seasonal?
Last winter we got shut down because of so much snow, but if it's a mild winter, we continually work.
Okay. And do you have work set up for this year?
We have worked for several years in a row if, again, the weather
Okay.
permits it to go on. The ice storm has damaged so much.
What do you do for hobbies and enjoyment?
Hunt and fish.
Have you had any other convictions set aside?
No, sir.
Describe for the judge what your normal daily routine is.
And in the morning we get up, everybody meets at my big barn, and then we go out to different houses around Burt Lake, mostly the Indian River, some Sturgeon River, some. Take down trees, grind stumps, put in topsoil, fix all the
Okay.
anything around the yards, just outside work.
And what time do you meet?
8:30,
And what time do you stop work?
7.
7? So you work a 12-hour day approximately?
Well, by the time we get on the jobs, so we do a daily rate. Usually the people that I work for, we give them a big day. and so we're there for at least 8 hours, and I like to do 10.
I think that's all I have, Judge. Let's-
Okay, any cross-exam?
Yes. I know it's a long time ago, but just for the record, in 1996, you did have an operating while intoxicated conviction out of Sheboygan County?
Okay, yep. Well, it was still like I was still drinking. I think, yes.
And at that same time, part of that case, you also had an assault conviction that you pled to.
Possibly. That was days when I was drinking and not doing well.
Okay. And you successfully completed probation in both of those cases?
Yes, I paid all the monies I owed and tried to do everything I could to better myself since those drinking days.
Okay, thank you. No further questions.
Any redirect?
None.
You can step down, sir. Any additional proofs, Mr. Losnick?
No, Your Honor.
Any proofs from the people?
Other than we did try to contact the victims, one was deceased and the other we were unable to get a hold of after leaving messages.
Okay, thank you. Argument, Mr. Losnick?
Yeah, I think as the court indicated, he's met the statutory requirements. This happened almost 3 decades ago plus. He was involved in a lifestyle that wasn't appropriate. He, I guess, basically could say he grew up. Since then, he's been a worker, person that provides jobs in the community, and has been a success. So I think he's an appropriate candidate to have these convictions expunged.
Thank you, Ms. Goodrich.
Your Honor, for those reasons that Mr. Losnick expressed, I would agree with the relief being requested.
All right, Mr. Woolard, yeah, those were a long time ago, and although you had a couple issues since then, it's even then been almost 20 years since your DNR thing, 16, 17 years for that, 20 years since the drinking and driving and assault, and 30 plus years for these felonies. It sounds like, you're a hard worker and you're not a person that gets in trouble these days. So I do find that all the statutory requirements have been met, and Mr. Losnick has checked all those appropriate boxes on the form. And I also find, based on clear and convincing evidence of the testimony here today, my review of the files, that the circumstances and behavior of the applicant from the date of the convictions to the filing of the application warrant setting aside the convictions, and that doing so is consistent with the public welfare. So, Mr. Woolard, I'm granting your relief.
This is huge. The judge officially wipes away convictions that have shadowed this man for 30 years. A reminder that while some defendants crash and burn, others can rebuild, reform, and walk out with a clean slate.
And setting aside both of these convictions under Michigan law and signing and dating the order. And we'll present this back to Mr. Losnick for filing with the clerk.
And I understand that then the clerk sends it to the appropriate parties.
Yes.
Okay.
Okay.
Thank
Sounds
you.
good.
Is that you writing it today?
Yes. Thank you.
We do an abstract or something down to the state, right? About that.
Okay, so I'll leave it.